Hi, my name is Ken Walsleben. I'm a professor of entrepreneurial practice at the Whitman School at Syracuse University. Prior to becoming a professor, I built and ran my own finance company, providing invoice factoring services to small and mid-sized growing businesses. I did that for over 20 years. And during that time, I worked with many entrepreneurial firms who sold their goods and services to big box retailers. I want to provide you some essential knowledge about the law and some of the processes that you go through when working with big box retailers. So what will follow here will be some quick hits on things you need to know about with regard to purchase orders, invoices, and also collateral. So my first order of business is to basically suggest to you that I'm not an attorney. All right. So let's understand that while I've been a practitioner in this space for over 20 years, the advice I'm providing you is that of a business person. I'm not a lawyer by trade. I've worked with many lawyers, and in fact, in this particular area of law, I probably know more than many lawyers. Still, please don't rely on my advice as legal advice. And do be sure to seek the services of an attorney if you need one. Now, the other thing to bear in mind is that I'm preparing this video for you as veteran entrepreneurs to be able and be more prepared to do business with big box retailers. And that phrase, big box retailers, is somewhat frustrating to me because it's a mouthful. I have to continually say big box retailers. So for convenience, during the course of this video, I may refer to firms like Walmart or Target or Home Depot, Lowe's, Walgreens, etc. Please understand I'm not referring to them by name and specifically referencing that particular company, but rather using their name as a filler, as a space holder, instead of continually saying big box retailers. So unless I clarify specifically that I'm talking about one of these firms, please understand that I'm just using their name as a placeholder. So let's dig in. Let's understand purchase orders, because purchase orders are pretty critical for you. You might sell your goods or services to others and not get purchase orders but from a big box retailer, you're going to get a purchase order. So the good news is that you after working with their buyer for a lengthy period of time, you've figured out how to arrange a sale. They've stepped up to the plate and they've ordered 20,000 units, for example, from you. You should know that a purchase order is legally binding upon that issuer. So the party who issues the purchase order is saying, should you, veteran, perform on this purchase order under the terms listed herein, we are obligated to pay you for your delivery of goods or services. You should also know that once you accept it, it's legally binding upon you to perform, which, and said differently, means that if you don't perform to the specific terms referenced in that purchase order, if you haven't dotted all the I's or crossed all the T's, they have no legal obligation to pursue and follow through with the transaction. They can turn their goods right around back to you. So please understand that all those pages that go along with that purchase order, they matter. The first page might talk about all the wonderful stuff, which is you're selling 20,000 units for $10 a piece and all the rest. But the next 8 to 10 pages, or however long it is, of small print legalese is pretty critical to you. And if you don't follow everything there, you won't have a binding issuer. In fact, you might find that you messed up the relationship. So do pay attention to everything that's in there before you sign and accept that document. Now, some of the fine print in purchase orders will clarify, for example, that you have to deliver on a specific date and that you have to send your goods to specific distribution centers in the following quantities, X, Y, and Z. You might also find out that you don't have a true sale. Now, let's first define a true sale. A true sale is as you would expect. You know, Walmart has ordered your goods, you've delivered on them, you've followed their rules. They now owe you payment in 30 days. That's a situation where Walmart, by this example, is buying your goods. They now own them irretrievably, unconditionally, and they have a duty to go sell them to their customers they see fit. You might find, unfortunately, that you don't have a true sale. You might have a sale that's conditioned upon something. All right. It might be conditioned upon their ability to sell the goods. So let's understand some terminology that you might bump into on your purchase order and understand the implications before you accept your purchase order. You might find that it's a consignment sale. What's that? The consignment sale basically is you're lending the goods or services to the big box retailer. You're sending it off to a Home Depot or Lowe's and hoping that they'll sell it. And if they sell it, they will then send you the proceeds based on the purchase price that they're agreeing to. Said differently, if they don't sell it, or if they don't sell it at the price they envision, they can either reduce your payment or return your goods. And that could come as a very unwelcome surprise down the road. So you really need to understand consignment sale. Now, if that scares you, let me try and really rattle your cage. Let me introduce you to a phrase called pay on scan. If you see this in there, be very cautious. What this means is that the retailer, Walgreens by this example, doesn't owe you any money until such time as they scan the goods through their point of sale terminal. And further, that you are responsible for any loss or theft while this product is on the shelves. Said simply, they don't owe you anything except for what goes through on the scan. And at some point, they may return your goods, and you might find that there's a shortfall. There's a difference between what they say they sold and the remaining inventory that they return. That difference, in polite terms, is called shrinkage. What it really is product that disappeared somewhere along the way. Guess who's on the hook for it? It's not Walmart. It's not Walgreens. So do understand what that limitation means and try and negotiate your way back to a true sale whenever you see something that's conditioned like this. Now, you'll also find language about allowances. As you can appreciate, the big box retailers, they've got customers in there periodically returning goods. Maybe they didn't like the color, but they opened the package. Now it can't be resold. Maybe they found that it didn't meet their needs and the retailer took a return of it. The retail manager at each location has authority to decide which of the products they wish to return and which they might deny the purchaser. Well, as you can imagine, they're not looking to get into a food fight with their consumer. They want to keep good relationships with their consumer, so they're rather liberal in their acceptance of returned goods. They don't run it by you first. They don't check with you. That's impractical. So built into a typical purchase order will be allowances, some percentage of the sale that the retailer can accept back and return goods that they do not owe you for. So you might sell 20,000 units and think you're going to get paid on 20,000 units, and you'll find out that that's not the case. When you eventually get paid, you're going to have an allowance of 10%. You're going to get paid on 18,000 units. Get the idea? Allowances matter. And additionally, you might find terminology like co-branding or co-marketing or similar phrases to that effect. What's that all about? Well, therein is a situation where the retailer, Home Depot or whomever, is going to spend some money to market your goods. Well, they're not going to do it all on their own account. They're going to expect you to share in that cost. So they might put it in their circular flyer. They might put it into their online website. They might create a special end of aisle display. Whatever it might be, they're going to ding you typically for half of what they say it cost. Were you planning on that when you got your check in the mail from them? Probably not. It could be a rather substantial ding. The other thing is, what happens if their goods don't sell at the expected price? What if they have to reduce the price? Maybe the retail price to the consumer is $20. You sold it to Walmart for 10. But what if Walmart can't sell the goods at 20? People aren't buying it. Walmart's going to mark it down. And when they mark it down, oftentimes that comes out of your side of the deal. Or at best, they'll share in that markdown with you. Pay attention, guys. This stuff happens all the time and causes a lot of payment dilution. You might be expecting a check, a nice big $200,000 check in 30 days. You find out you get a check for $130,000 with all sorts of fees and dings like this. Or you might get a check for $100,000 and a return of goods. In either case, that's an unwelcome situation, and you need to be aware of it. So with regard to markdowns, return on inventory, be sure that things are referenced in that purchase order. After all, that's basically the book of rules upon which the big box retailer is willing to be held by. So do's and don'ts. Don't be late. Your purchase order will reference a due date, a delivery date, no later than blank, and it has to be delivered to multiple distribution centers. Follow those rules. And please understand that if you're so much as an hour late in delivery, that makes that purchase order null and void. They are no longer obliged to follow the rules or the pricing there. So what might happen is a savvy big box retailer might say to you, geez, you missed your delivery. We can still use the goods, but we're not going to be able to sell it at that same price. Rather than buy it from you for $10, we're going to pay you $9. Take it or leave it. Unwelcome news simply because you were late. They're going to give you instructions on labeling the boxes. Distribution centers are busy places. They can't just open the box to look what's inside. They need to read the code on the outside of the box to figure out where to inventory it, where to warehouse this particular product. Also, you want to track delivery. You want to ensure that you can prove that it was delivered on time. So you want to retain your proof of delivery or acceptance from your logistics company. You're also going to want to ensure that your product is sale ready, right? They're not interested in packaging your raw goods. They want to know that your goods are already packaged, that have the applicable barcodes and everything else so that they can simply hang it on the shelf and know that it's going to run through their POS system up at the front of the store. So follow their instructions to the letter. Should you use a shipping broker or a shipping company? Please understand the difference. Brokers, as the name implies, are independent companies. They are not the ones shipping, but rather they act as kind of a clearinghouse between you as the the company requiring shipping and the actual logistics company completing the shipping. These companies sometimes have great visibility, sometimes they have great service, and they also pretend or claim to be cheaper. So it's an attractive business model if you've got the right broker. But please understand that these brokers can dry up and blow away in the wind almost overnight because they really have no assets. They're simply a clearinghouse, a bunch of tables in a back office working with shippers and logistics companies. You might instead want to work specifically with a logistics company, party actually doing the delivery, so that you have clear communication and visibility with them and the status of your order. Let's move on to invoices. You think they're simple, you just simply bill your customer. Did you know that there's a body of law that covers this and that all of the invoices must already be completed to become an invoice? So did you also know that invoices are enforceable upon the purchaser? Let's get into the weeds here a little bit and really understand what's going on. As I mentioned, all goods and services must already be delivered for an invoice to be enforceable. You must clearly identify the party who owes the money by legal terms, meaning if it's Walmart, for example, it's Walmart, comma, Inc. or Walmart Corp. or whatever it is that was referenced on the underlying purchase order. Don't just simply say Walmart. Also, you want to reference the goods or service that are being invoiced. You need to be specific as to what is being invoiced. So you need to have an itemized listing of those things that you're invoicing for, along with the breakout of price. If there's an underlying purchase order, and there almost always is, reference it. Be sure that you are invoicing consistent with the terms on the underlying purchase order. For example, if the purchase order says that they will pay you in net 30 or net 60 terms, be sure that the invoice references that same language. Be sure that you're addressing this and delivering this to the proper place of business for your customer. Don't send it along to the distribution center where you delivered your goods because they don't know what to do with it, or it'll just be held up dramatically. So be sure you send it to the right party. Reference a clear due date on the invoice. Did you know if there's no due date, it's not enforceable? Also, reference any applicable early payment discount. If you're going to offer them, excuse me, a discount of 2% over 10 days, be sure that that's referenced. Clearly state where payment should be sent to and your specific legal name. If your invoice doesn't have a unique identifying number, it's not enforceable. So have one. And if you impose any late payment penalties, or if you intend to, your invoice needs to reference that to be clear. So, excuse me. Bottom line is that there's a lot that goes into an invoice. It's not just a piece of paper to slap some information on and send it out. You really need to follow through correctly. Let's move on finally to collateral. Collateral is oftentimes completely misunderstood by entrepreneurs. Do understand that if you're working with a lender or an investor or whomever you might be pledging collateral to, please understand that that is negotiable. Don't back into unknowingly giving your customer a blanket lien. I shouldn't say your customer, but your lender a blanket lien. So by example, you must understand that there are different classes of collateral assets. And for example, you want to be sure that you don't pledge all of it to any one party. Most of the time, entrepreneurs make the mistake of providing a blanket lien against all assets to their original lender, the first lender who gives them $50,000. They just simply sign the documents because it looks all like it's boilerplate and regular legalese, and it likely is. But in there will be some language. Hear this. It will say something to the effect of borrower hereby pledges to secured party first collateral lien interest in all of borrower's present and hereafter acquired assets. Now, if that buckled your knees, welcome to the party. It should. The reality is that oftentimes that language is buried deep in a loan agreement somewhere. But what it really means is that you've hooked your wagon to that lender and that lender only for the entirety of your relationship. Said differently, until such time that you can pay off that lender for that obligation, you can't work with anyone else. That's not a corner you want to be backed into. Ideally, you want to be able to provide yourself some wiggle room if you go back to that first lender for an incremental loan later and they say, sorry, we're not going to give you any more additional funding. If that's the answer, you want to have some cards to play. You want to have some assets to pledge to another additional lender, be they a purchase order funder or a factoring firm or an asset-based lender. For more information on those parties, I direct your attention to the tutorial entitled So the Bank Said No, Now What? But let's finish our discussion on collateral this way. Let's understand that there's multiple types of assets that your company will likely develop. By law, there are two classes. The first of which is real estate, real property. We're going to ignore that for now. Odds are you don't own a building or a particular asset of real estate that you're going to sell. And even if you were, from a pledge standpoint, that's a completely different conversation. What I want to talk about is what the law calls personal property, which I call everything else. Now, please understand this is not your personal property, but rather the personal property of your company. Things like equipment, inventory, accounts receivable, furniture, fixtures, and leasehold improvements, and general intangibles. General intangibles could be a patent, trademark, the rights to an insurance payment. Basically, anything that doesn't fall into those other categories kind of falls into general intangibles. The reality is, unless you know to negotiate these 5 cards, they're going to get pledged to the first lender who asks for collateral. And you will unknowingly back yourself into that corner. I want you to be able to play these cards, much like you're playing a hand of poker. You're not going to give all these cards to your opponent, nor should you give them all to your first lender. The reality is this is negotiable, and you need to negotiate it before you close the transaction, because that's when you have the lender's attention to work something out. Which of these assets is most likely to be, for the lender, most likely to give up? It's accounts receivable. So play the card. Say to the first lender, look, I understand you need collateral. I get it, but I need to avoid a blanket lien. On the chance that someday you might not be able to say yes to me, I need to have the flexibility to move on to an additional lender. I need to keep accounts receivable outside of your collateral lien. Odds are really strong the lender will agree to do it. They won't immediately, but stick to your guns, dig your heels in, and they will normally give in on that. That's words of advice from the real world, having spoken to hundreds of entrepreneurs who mistakenly provided blanket liens to their first lender. Don't make that mistake. That concludes this quick hits video. For more details and a deeper dive into any of these particular categories, to better understand the legal ramifications and the law upon which you operate under, I direct you to the full-length video tutorial on this particular issue called Essential Legal Information. I wish you well. All the best of luck.